Hello, and thank you for viewing Lehigh Valley Center for Independence Living co-presentation with North Penn Legal Services, Understanding and Enforcing Housing and Fair Housing Practices. We'd like to thank Sarah Andrew over at North Penn Legal Services for facilitating this program, and Christine McIntyre for taking the time to put together and present it. Christine, if you'd like to go ahead.
Yes, I would. Good morning, everyone, and thank you so much for joining us. Today, we're going to be discussing understanding and enforcing housing and fair housing protections. And this presentation is by North Penn Legal Services. So we're just going to ask that if anyone has any questions, they would either type it in the chat or reserve their questions until the end of the presentation. All right, and with that, I'm going to begin. I will mention really quick that there is a barcode at the very beginning of our cover slide, if you will, title slide. So if you scan that with your phone, you could use it to view our self-help handbook for tenants in both Spanish and English. Okay. All right. So where do we begin with housing? Landlord-tenant law basically started in 1951. It set forth obligations of the landlord and responsibilities of the tenant, including the eviction process generally, which in the state of Pennsylvania applies both to written and verbal leases. But it does not apply to rooming houses or other temporary housing situations. The landlord-tenant relationship is based on a contract, which is commonly called a lease. And like I said, the lease can be written or verbal. And case law sets forth warranty issues, which we will get into in a little bit. The eviction process has some basic, components. A landlord cannot lock out a tenant or make the unit unlivable to force the tenant out, which is commonly called a constructive eviction. Landlords must follow a legal process to evict tenants, and that legal process entails taking them to court in the form of a notice to quit. So giving the tenant notice that they're going to be sued. Time
Christine,
to schedule
I'm sorry.
it.
I'm sorry to interrupt. Are the slides meant to be progressing, because we're still on the title slide?
Oh, dear. Yes, they are meant to be progressing. It's progressing on my screen. I'm sorry about that. Let me change this for a moment. I'm so sorry. Give me a second.
Oh, not at all.
All right. Can you see this?
We're still on the title slide.
Okay, so nothing's working for you. Oh boy. Okay. Sarah, do you mind sharing the screen?
Yes, 1 second.
I apologize, everyone.
Okay, and Christine, if you can just tell me when you'd like me to advance.
Okay, could you go to the next 3 slides, please? Okay, so like I had mentioned, the tenant, oh, okay.
Sorry.
No worries. Okay, so the eviction process has several stages, like I mentioned. First, the tenant would need to receive what is called a notice to quit, which is either a typed or handwritten notice, typically posted on the tenant's front door, indicating that the landlord is asking them to leave by a certain time whether that's the end of the month or, 45 days or 60 days in advance. And if they fail to leave, the landlord can seek, eviction in court. There are different filing notices between non-payment of rent versus a breach of lease. If it's for a breach of lease for criminal activity or an end of lease term, you only have to give, I believe, 10 days. If it's non-payment of rent, you have to give 15 days notice before the landlord is entitled to actually go to court and file a complaint to seek eviction. The tenant receives the complaint and the notice of the hearing by the magisterial district court in their particular district. And then the hearing is then held and judgment is issued. So that's like a very brief overview of the process. Next slide, please. There are two types of judgments. Possession granted is what we consider to be called a straight possession. It's to give possession to the landlord. The appeal decision, the only remedy to preserving your housing at that point is to appeal. So you must appeal to avoid eviction in that case. And you would have to do so within 10 days of the hearing date. The other type of judgment is possession granted if money judgment is not satisfied. This is commonly called a pay and stay judgment, where the tenant can avoid eviction without filing an appeal if they pay the judgment amount in full within a certain time period. Typically, they would have to pay the judgment directly to the landlord within 10 days after the hearing itself. If they fail to do that, they would have to come up with the money in exact form, cash only, by the time possession can be issued and requested after that 10-day time. So they would need to come up with the money directly for the constable. Sorry, I'm like talking in circles a little bit. Next slide. Okay, so the appeal process for a straight possession case is, like I said, 10 days from the date of judgment to file an eviction appeal. The appeal is filed at the county courthouse and costs money. Filing fees can be waived through a process called what we call IFP, which stands for in forma pauperis, which is a special petition that the tenant can make for the Court of Common Pleas to get those filing fees waived. However, what cannot be waived is a bond, which is actually commonly called a supersedious. And it's basically the equivalent of a rent payment, the first month of which, if a tenant is filing for IFP status, would be broken up into 1/3 payment upfront at the time of appeal, and then 10 days later, the other remaining 2/3 rent payment. So say you have, for example, $900 in rent per month, and you appeal a straight possession judgment. You would need to come up with $300 the day that you appeal, exact change, cash, or money order, and then appeal. And then you would need to come up with the remaining $600 in 10 days. And then every 30 days from the date of appeal, you would be responsible for your full month rent payment to the court so that that supersedious bond can be posted. If you fail to pay that supersedious bond, the landlord at any point past that deadline that you fail to pay by can request an order for possession, which will be granted if the payment is not made. So next slide. So with that sort of situation, if no appeal is filed, the landlord will obtain an order of possession from the court, in this case, the district court, because the Court of Common Pleas would not be involved. The order of possession gives the tenant approximately 10 or more days before they must vacate the apartment. So the total process at the district court level is typically around 21 days if the tenant does not appeal, from the time of hearing to the time of physical eviction by the constable. If the tenant is unable to file the appeal to stay in the apartment, the order will list the exact date that the tenant must vacate on it, and some of whom actually have the time on it as well. If the tenant doesn't vacate by the stated date, the constable will come and remove the tenant from the apartment. The tenant would no longer have physical access to the unit or his or her belongings. So it's really important to make sure that the tenant has arrangements in advance, whether it's a storage unit or somewhere else that they could go, a hotel, stay with a friend, to avoid being, cut off from your belongings, and especially important documents. Next slide. So with a pay and stay judgment, the tenant can pay the judgment in full to avoid the eviction. The tenant can pay any time before eviction, even after an order for possession is obtained. But like I said, before the order of possession, they can pay the landlord and then seek to mark the judgment satisfied, which they must request in writing to the court, and get that on record, so that there would be no potential judgments on file for them. If they don't do so before the 10 days have passed, they would have to pay the court in full or the constable. They can file an appeal if they disagree with the judgment amount. If you believe it's too high, or it's not right, or you're somehow entitled to an offset, because of some warranties, which we're going to discuss in a moment, then there is the ability to appeal that as well. If the tenant doesn't appeal, satisfy the judgment, or vacate by the eviction date, the constable will forcibly evict the tenant. Next slide. Okay, so there are a couple different warranties. The most important one to remember is the warranty of habitability. This is an implied warranty. An implied warranty means that it doesn't have to be written in the law. It's implied, which has something that has been previously established by case law. So the judges, attorneys, landlords, they all know that a tenant has, the right. And I say the tenant has the right. The landlord has the obligation, and the tenant has the right to have safe and sanitary conditions for tenants. What does that mean? What is safe and sanitary? Working heat, working smoke detectors, an apartment where it is free of insects or rodent infestation, free of mold, things like that. And it's also a means of getting repairs made. So a landlord can't get around the law by claiming that the tenant is renting the apartment as is. So if you ever see a lease where, or a notice where the apartment is being rented as is, that's not true. And the landlord is trying to get one over on you. So just remember that whatever they try to say it is, they are obligated to provide safe and sanitary conditions for tenants. Also, cities and municipalities often impose higher standards that are more specific, in the form of code enforcement. So for example, the city of Allentown has a building and standards department, and within that department, they have a couple different code inspectors who perform the function of enforcing their specific city standards. Next slide. The process for requesting repairs is not as daunting as it seems. All you have to do in most cases is, send a text message to your landlord. You have to give them the opportunity to make a repair first. You have to give it time. keep track of all the calls and the requests, save, screenshots of your text messages or your emails. But the important thing is you really should try to have it in writing. Phone calls are great, but they don't actually help you in court. An email or a text message would show that you physically made the request and you're asking for this repair to have been made. The timeline for repairs being made depends on how severe a problem can be. So you can have a leaky sink, which, may not be as big of a deal compared to no heat, or your toilet is broken. If there is no response in a timely manner, the tenant should then notify the landlord in writing. And again, they're saying you have to do it in writing now. I always tell my clients, get it in writing, no matter what stage of the process is. And if it's a serious problem and, the landlord fails to do anything about it, again and again, then you call code enforcement. Be aware though that there are some potential ramifications to that, which we can discuss in a bit, not to discourage anyone from calling code enforcement, but sometimes calling code enforcement exposes a little bit of a Pandora's box with issues in a particular apartment that risk potentially displacing the tenant as a result of possibly inhabitable conditions. But anyway, keep proof of the problems because this is very, very important. Photos, text messages, if you repair and deduct, from the rent, keep track of that, any receipts that you have. And next slide. So like I said, repair and deduct for smaller repairs. If it's something minor, if it's a substantial issue, that's really when you want to involve code. For example, if the mold in your apartment is just so overwhelming and your landlord is just not fixing anything or making any real attempt to remediate the issue, then I think it would be perfectly acceptable to involve code. So repair and deduct is the one option. Option two is to break the lease entirely and move out. If you don't want to expose your family to mold and pests, that is an option. I know it's less of an option now in the post-COVID era with the demand for housing being so insane, but it is an option. And option three is withhold the rent. So it's not recommended because the landlord can sue and most likely will sue for non-payment of rent in its entirety. A lot of times, withholding the rent outright is not really completely justified. You could try to make a case for, okay, well, my heating bill would be $200 maybe a month for my share of the building, which is still high. But if it, say it's the height of winter, I'm gonna deduct that much from my rent, and I'm putting you on notice that I want it fixed, and I'm not going to pay the whole rent until that time. Typically, judges will honor, partial withholding. Sorry. And then finally, you can sue the landlord for back rent and other expenses, which can get complicated, especially if you don't have a whole lot of evidence on your side. But the point is, you have to notify your landlord that there are some problems in the unit, and you have to give them an opportunity to fix. If they fail to fix it, these are your options. Next slide. Okay, so with the property left in the home after you have left, whether it's voluntarily or because of the constable. You have some options about, getting back your belongings. So within 10 days of vacating the unit, the tenant must give written notice. Once again, text message, email, you can even put a note on the office door that, your property's not abandoned. You are intending to get it back. You want to give the landlord your contact information. They can hold your property for at least 10 days after the tenant vacates, but they can start charging you storage fees after those 10 days. They can't hold your property hostage, can't demand rent, to release the property. That's not acceptable. The landlord must safeguard your property for at least 30 days. They can charge the storage fees after 10 days though, which could get pricey. So I always tell my tenants, try to really get everything they can out within those first 10 days. Next slide. Okay, so this topic is pretty popular among my clients. They always want to know, when am I going to get my security back? How do I get it back? What do I do? Well, so a return of security deposit can't be waived in the lease. When a tenant vacates the property and returns the keys, they are responsible to give the landlord written notice, once again, that writing requirement, of where to send the security deposit. So you need to give them a forwarding address. The landlord has 30 days from the tenant's move out date to either return the security in full or give the tenant an itemized list of damages. The tenant can always dispute the damages, but if the landlord fails to return the security deposit or send a list of damages at all, so if the landlord doesn't do anything after being given written notice that, the tenant has moved and this is their address, the tenant can then sue the landlord for double the amount of the security deposit. So it's called double damages. Landlord would then lose the right to keep the deposit for damages. So that is an option for a tenant who feels like they have been wronged. Next slide. Okay, so the eviction process with respect to COVID rules. There are technically no more COVID-related eviction protections for tenants in place. The last one expired, I believe September 30th, federally. Unfortunately, in the state of Pennsylvania, Governor Wolf has not moved to make an executive order to extend any COVID protections for tenants. So unfortunately, there is no more immunity, if you will, from non-payment of rent. However, there is something called ERAP, it stands for Emergency Rental Assistance Program, which is administered by several local agencies. Next slide. Okay, so I had added a slide here, which lists Lehigh Valley agencies that are administering ERAP funds, and they all depend on where you are located, which county, and or which city or township. So anyone who's watching that needs to apply for emergency rental assistance can do so at these following agencies. You just have to look to see where you live and then try to match it up with one of those agencies. We deal a lot with New Bethany Ministries and Catholic Charities. I've had 1 or 2 cases with Third Street Alliance and Easton Area Neighborhood Center. To my knowledge, these agencies are still accepting applications. But if you're not sure where to apply, I did put a link at the bottom of the screen, and you could click on that link and I believe input your address and it can match the agency for you. Next slide. COVID emergency rental assistance. So what is it? Well, it's money given to agencies by the federal government to pay landlords for non-payment of rent that had occurred during the COVID-19 pandemic. Some things to remember: agencies can accept certain factors as proof of eligibility. There's no requirement that the money go directly to landlords. So if you have a case where the landlord refuses to accept money, they can give the money on a case-by-case basis to the tenant to pay the rent directly if the landlord is being particularly stubborn. Landlords cannot evict during the period they are being paid by these funds. So if that is the case, you need to notify my office immediately if the landlord had accepted and cashed those funds and then sought to evict you within the same time period. If the tenant receives a subsidy, they would then qualify for their portion of the rent. You don't need to be behind on rent to apply, and assistance can be given to people evicted and moving to new housing. So it just depends on, what the facts are with your situation and, what kind of funding they have available. And it all depends on, what that particular agency's eligibility requirements are. Next slide. So those requirements. So one or more people in the household have qualified for unemployment benefits or experienced a reduction in household income or incurred significant costs or experienced other financial hardship during the pandemic or due directly or indirectly to the pandemic. So it doesn't have to be directly related to the pandemic. And this is what we've been telling our tenants. A lot of people out there think that they don't qualify because they didn't have, a job loss because of COVID. They weren't, the initial group of people that were laid off, in March of 2020. But I always encourage clients to apply, because it doesn't hurt to apply, right? Because at least you're trying and you never know. The second component for an eligibility requirement is that one or more people in the household can demonstrate a risk of experiencing homelessness or housing instability, and the household is a low-income family as defined under federal regulations. So typically, what you would do is look up, the agency would look up your status based on income, based on the federal poverty guidelines, and that's based on how many individuals are in your household. So that can range. Next slide. Okay, so the Fair Housing Act, it's a wonderful law. It's actually a group of laws that protect certain individuals, protected classes from discrimination in housing transactions. The laws apply to dwellings, which are structures designed or occupied as residences or land offered for sale where a residence will be built. Next slide. Okay, so what are these protected classes that I had just mentioned? Well, they can encompass a lot of things. It can be based on race, color, national origin, religion, sex, familial status, and disability. Next slide. So what is a dwelling? Well, it could be a lot of things. Rental properties can be either private or subsidized. Homes for sale, manufactured home communities, also called mobile homes, group homes, rooming or boarding houses, nursing homes and assisted living centers, residential drug and alcohol treatment centers, homeless shelters, which is on a case-by-case basis, university housing, and even vacant land offered for sale or lease. Next slide. So there are some exceptions to what is classified as a dwelling under the Fair Housing Act. So the Fair Housing Act, unfortunately, doesn't apply in a situation where there are, in Pennsylvania at least, 2 or fewer units if an owner lives in one of the units. So for example, say you have a duplex that you are renting from, and the owner is your landlord, and he's also your next door neighbor. So in that situation, the Fair Housing Act would not apply. Single family housing sold or rented without the use of a broker. So if it's owner sold single family home, it doesn't apply to the Fair Housing Act, but only if it's like a one-time thing, or the owner is selling less than 3 single family homes. Housing operated by religious organizations and private clubs can give preference to members, but cannot discriminate in their membership by itself. And finally, senior housing, because they are allowed to make exceptions within their own communities for individuals 55 and over. So in that case, they can make an exemption and say, oh, no children, which would actually not be a Fair Housing Act violation. Next slide. So laws and regulations specific to federally funded housing. So the U.S. Department of Housing and Urban Development, called HUD for short, has what we call an equal access rule, which requires equal access to HUD programs without regard to actual or perceived sexual orientation or gender identity or marital status in HUD assisted housing, housing where financing is insured by HUD, or FHA insured mortgage financing. So some assisted housing that is owned and operated by HUD is public housing, project-based Section 8 and Section 8 housing choice vouchers, which are actually tied to the individual tenant, not the property. Project-based is property-based. And then, so say that you were a family, for example, who was applying for an FHA insured mortgage. Say that, for example, you couldn't meet the 20% down payment that everybody, hopes to have when they buy a house. There are certain loans that, help somebody make a home purchase, and they could be FHA insured mortgaging. So that example would be a protection for somebody who is looking to find housing and had, financing through the FHA. The Section 504 of the Rehabilitation Act prohibits discrimination on the basis of disability in programs and activities conducted by HUD or recipients, of financial assistance from HUD. It enforces the right of individuals to live in federally subsidized housing free from discrimination on the basis of disability. It covers all HUD programs except for its mortgage insurance and loan guarantee programs, and it forbids organizations from excluding or denying individuals with disabilities equal opportunity to receive program benefits and services. I know that was a mouthful. Next slide. Okay. So states and cities and local municipalities can offer additional protections. The Pennsylvania Human Relations Act states that it is illegal to discriminate on the basis of age. If you're over the age of 40, it is also, illegal to discriminate for those who handle or train, support, or guide animals. It protects tenants associated with individuals with disabilities. So someone who is a family member of a person with disability, and it gives guidance on sex discrimination. So, and then the cities of Allentown, Bethlehem, and Easton also have a rule that states that you cannot discriminate on the basis of sexual orientation, gender identity, and gender expression. You also cannot discriminate on the basis of marital status. Next slide. So how is the Fair Housing Act enforced? Well, you would start with negotiating with the landlords. Typically at that point, my office or another office would be involved. You'd raise the issue at an eviction hearing as a defense. You would file a complaint with HUD, which is the federal government, and I can provide the link if anyone has any questions about that. The statute of limitations to file a discrimination complaint with HUD is 1 year from the date of last incident occurring. The Pennsylvania Human Relations Commission is the state entity involved, and they would give you 6 months to file from the date of the discrimination, the last incident of discrimination. And then the Human Relations Commission, it depends on the city. So they can have different statutes of limitations depending on, where you are. The time to file a lawsuit, however, in state or federal court can take up to 2 years. So I always tell my clients to, really think about, whether they're going to pursue this, if it's something they're prepared to, be engaged in for a long period of time, and whether it's, worth it, to be frank. Because you need to make sure that you have evidence. And unfortunately, in a lot of discrimination cases, there is no actual evidence of discrimination, because a lot of times the discrimination is, said over the phone or inferred, in speaking with somebody. It's not, actually blatant in writing, unless, for example, it was an ad for housing. But I'm not saying it's not impossible, and I'm not saying that, you shouldn't file if you really believe that you do have a case, because, landlords need to be held accountable just like anybody else, and they need to, know that their behavior is not acceptable, and will not be tolerated. So next slide. So I just wanted to, before I get into this slide, also mention that when a HUD complaint proceeds, they typically file what you call like a determination, a favorable determination, or I'm sorry, a determination of merit after a certain period of time. And my office does not typically file HUD complaints for individuals. We just help them do it themselves. But they would get involved, undergo a fact investigation period where they would determine whether your claim has merit or not. And if it does, they can issue what is called a right to sue letter, where you can, then pursue a claim in federal court, which can again really extend the timeline to hold these property owners accountable. Okay, so we are going to talk about what is the definition of disability. An individual with a physical or mental impairment that substantially limits one or more major life activities, or is regarded as having such an impairment, or has a record of such an impairment. Additional protections can make requests for changes if such changes are needed to allow them the same full use and enjoyment of the premises as an individual without a disability. And changes requested must be directly related to the disability. So there must be a nexus, which is really just a connection between the changes sought and the disability. Next slide. Just going to sip my water. What are those requests for changes called? So there's two different types. Excuse me. Reasonable modifications and reasonable accommodations. A reasonable modification is a structural change to the interior, exterior, or common areas, costs of which are paid by the housing provider if you are in federal funding or Section 504 housing. A reasonable accommodation is a change, exception, or adjustment to a rule, practice, service, or lease policy. And a reasonable accommodation can be requested at any time prior to actually being evicted. Next slide. So what information can the housing provider request? Well, they can ask the tenant, medical provider, or social service provider to confirm that tenant has a disability and the request is related to the disability. You can't ask for the tenant's diagnosis, and you certainly cannot ask the tenant for more information or medical verification if the disability is obvious or the housing provider already knows the tenant has a disability and the need for the request is clear. Next slide. Some examples of reasonable modifications include an individual with a mobility impairment requesting installation of a ramp or a stair glide, replacing carpeting with tiles, making a bathroom accessible, and having a stove with knobs in the front. An individual with cognitive or memory impairment can request installation of automatic faucets or replacement of the stove with a microwave. An individual with a vision impairment can request special lighting, color contrasting, tactile assistance system, extension of side rails or stairs, replacing curtains with blinds, installing grab bars or additional lighting. An individual with hearing impairments can request an installation of a peephole in the door, an installation of flashing lights for the doorbell and the smoke alarm. Next slide. Some examples of reasonable accommodations include that the housing provider allow for early termination of the lease so a tenant with a disability can move to an apartment that can accommodate them. They can also notify the tenant who has chemical sensitivities in advance of painting and exterminations. The housing provider can allow the tenant to pay rent according to when they receive Social Security disability payments. The housing provider can provide a handicapped parking space for a tenant or allow an assistance animal or a caregiver to move into the apartment. And finally, they can stop an eviction action to allow the tenant time to fix the lease violation. If it's time to clean, time to seek mental health treatment for behavior, additional time to move, etc. Next slide. So what counts as a reasonable accommodation request? Well, any request asking for a modification or accommodation because of a disability. So for example, if the lease says a tenant must pay the rent in person, the tenant can tell the housing provider, sometimes I get really anxious about leaving my apartment. Can I pay my rent another way? So money order or Venmo, something like that. You don't have to use the magic words reasonable accommodation. It can be oral or in writing, and it doesn't have to use the housing provider's specific request form. Next slide. So when can you request a reasonable accommodation? Well, the tenant can request one at any time prior to actually being evicted, including during the application process, while living in the unit, when the housing provider changes a rule or policy, in response to a housing provider's complaint or adverse action, an informal hearing, an eviction hearing, at the time of the hearing, or appealing to a higher court. Next slide. So the request process gives the housing, so the whole process is basically the individual gives the housing provider the request, in writing preferably, and the provider must respond in a reasonable amount of time, 7 to 10 days. If a housing provider denies the request, they must state a reason and discuss alternative options. An unreasonable delay in responding is viewed as a denial. A denial without reason is a violation of the Fair Housing Act. Next slide. Reasons for denying a request, typically in the form of a burden on the landlord. So if there is an undue financial and administrative burden, so for example, if they needed to install something that was just far too expensive and too invasive to the structure of the building, they could make an argument for denying that particular request. If it would involve fundamentally altering their operations, if the tenant poses a direct threat to the health or safety of other residents or staff, or if the tenant would cause substantial physical damage to another person's property. Next slide. So we always encourage, tenants to open a dialogue with their landlords and property managers. A tenant's request, should be really about their needs. If the request is denied, that's not the end. Even if a housing provider denies a request alleging that it is unreasonable or that the tenant is a direct threat or would cause substantial damage, they must talk to the requester about options. Next slide. So assistance animals, commonly called service animals or emotional support animals. This is a reasonable accommodation request as an exception to a no pet policy. They are not pets. They are emotional support animals, service animals. They must show the relationship between the need for the animal and the disability. So again, we're talking about that nexus, which you can get in the form of a letter from a doctor or social worker. A landlord cannot charge a pet deposit or an extra monthly rent for an assistance animal. There is no training or certification required. There are no breed or weight restrictions. All domestic animals are allowed, and the animal can access all housing property. Additional resources that I wanted to talk about are included on this page. There's a wonderful organization in addition to SIL that is called SDHP, which stands for Self-Determination Housing Project of Pennsylvania. There is the Office of Vocational Rehabilitation, commonly called OVR, which helps provide assistance with job searches, resume building, things like that. There is the Pennsylvania Department it's actually within DHS, the Bureau of Autism Services. And then there's various local county agencies who administer various services. And Compass is one that actually administers, all the medical assistance, SNAP, LIHEAP, and they actually do offer some home and community-based services for those individuals with disabilities who need additional services. Next slide. There's, of course, Social Security, the National Center on Law and Elder Rights, and they provide information on ABLE accounts and disability advocacy as well. There is a free housing search for Pennsylvania rentals, pahousingssearch.com. And there is a career website called The Link, which is it's through the Pennsylvania Department of Aging and Disability Resource Center, which provides, links on jobs and things like that. Next slide. And this is our information. So if anybody has any questions or they want to, give us a call, that's our number, 610-317-8757. And our intake line is actually 877-953-4250. Thank you so much.
All right, thank you so much, Christine. I do just want to let everyone know that this presentation was recorded and will be available on both LBCIL and North Penn's social media sites. I did have a few questions from throughout the presentation. Would you like me to go back to the related slides or?
Sure.
Give me a second to kind of.
I know there's a lot.
As far as the process for requesting repairs, you mentioned that the landlord has to get back to you in a timely manner. What is considered a timely manner for a response to a request?
Okay, so it depends on the severity of the problem. That's actually a very good question because there is a lot of room for a gray area. Typically, if you have a leaky sink, I would say, give it 1 to 2 weeks, for the first request. If they haven't responded after that, send another request in writing. That is not really as big of a deal, for example, as, your refrigerator breaking down or no hot water.
Mhm.
Because if you don't have access to hot water or heat or the ability to cook and store food, that is an issue. And you really need to see if you can get that restored ASAP. You would make that response, you would renew that response within a day or two, I would say. And if they fail to, say anything, if you don't have heat or hot water, you can certainly feel free to call code, I think, if the landlord fails to do anything within the week. I would say at a minimum, if you want to be more aggressive about it, you could do 3 to 4 days. But if it's the middle of winter and you don't have heat, you can certainly get more aggressive depending on how severe the situation is.
Okay.
If there's a specific example, maybe I can answer it better.
Let's say, for instance, that sewage starts backing up into the tub.
Okay. Yeah, that would be, I think, a situation where it's a public health hazard. So, you would be as aggressive as you can about that.
Okay.
Give them the time to respond, say, I want it done within the day. Because that would also be like a potential health hazard. Like I said, you're breathing that in. It's gross. And, you know, if the landlord fails to do anything within 3 days, you know, call code.
Okay. Thank you. Had another question as far as the break, lease, and move out option.
Yes.
If you take that step, can you be held liable for the legal repercussions that are usually associated with breaking a lease?
So typically, that's actually a very good question, because a lot of lease agreements have what they call acceleration clauses, that, you know, basically impose a liability on the tenant if they move out and break the lease early. But
Mhm.
then I would say, you know, I would wait for the landlord to sue you, because once they do, you can bring up your in your counterclaim, which is a separate suit, but you know, you don't have to pay for the filing costs of that. You can say, look, you know, they're moving for an acceleration clause, but I didn't they didn't do any of these repairs, and here's my proof of asking for the repairs and the proof that the repairs needed to be made, and they didn't do anything, and I told them I was leaving, and I think this acceleration clause is, you know, unfair and
Okay.
unenforceable. But I mean, in a situation like that, you know, they can certainly call our office and we can discuss it and how to, you know, move forward with that.
Right. Wonderful. Thank you. As far as the storage fees that a landlord is able to begin charging after the initial 10 days, if a tenant is not able to meet those fees and they're not able to remove the property, what options do they have at that point?
So after the 30 days are up, the property is actually deemed abandoned. And legally speaking, the property owner could do what they wish with it, whether that's, you know, sell it, dispose of it, use it, repurpose it in some other way. So it's really imperative that the tenant try to get their belongings, you know, within that timeline. If
Mhm.
you really believe that you just need a little bit more time, it never hurts to try to communicate with your landlord and say, look, you know, I just need another 2 weeks to get my things. And if they try to hold your belongings, you know, hostage, you could always, you know, call us and discuss.
Okay. Um, I know you mentioned they can't hold it property hostage for like back rent, but
Mhm.
can they refuse to release it on the basis of you're not paying their storage fees?
Well, so that gets complicated. I actually don't know the answer to that question off the top of my head, because if you think about it from like a storage unit company's perspective, part of their agreement, which is written, you know, with storage lessees, if you will, that, you know, if they fail to pay within that time frame and they're properly noticed, their belongings are deemed abandoned. But I think in that situation, in the situation of a property owner and storage of a few belongings, I would say it can be handled on a case by case basis. Um, they can certainly pursue storage fees regardless of, you know, say you come get it and you didn't pay them. They can certainly, you know, file a small claims action and seek storage fees for that. I have yet to actually see that. It's not really as common, but I just want to make people aware that this is what could happen.
Right. Okay, thank you. Jumping ahead to the ERAP, how often can an individual apply for ERAP assistance?
So it's my understanding that, and I don't know entirely if this is true or not, they're allowed to apply, I think, twice within an 18-month period. But it has to be like twice within, I think, one agency.
Okay.
They're allowed to apply to different agencies, but you would have to check to see what those agencies' rules are, because sometimes they won't let you apply if you have an open application with a different agency at the same time.
Makes sense, yes. As far as the, oh, here we go. The meeting the criteria for low income as defined under federal regulations. What do you know? Is there a time period that they look at that? Because you may meet the criteria due to these hardships, but you may not have 6 months ago.
Okay, so I believe that has to do with like the current tax year that we're in. I can
Okay.
check,
Okay.
but I'm not sure if it's based on, you know, what your income is, you know, within a particular month versus like averaged over a particular year.
Right. Okay, and then one final question on the assistance animals. You said they cannot refuse domestic animals. If a person has what is considered an exotic animal, can a landlord or housing authority potentially deny that?
Well, I guess it depends on what an exotic animal is.
Well,
Are you talking about a snake or a
yeah,
bird?
like or like what's oh, I can't think of the word.
Peacock?
Thank you.
Yeah, so
That'll work.
so this is a really good question. You guys have really good questions. I believe what they mean by domestic animal is, in this specific context, dog, cat, guinea pig, hamster, you know, things like that, bird.
Okay.
When you're dealing with a peacock, for example, that's not technically speaking a domesticated animal, but then you get into like the nuances of, well, some peacocks are raised, you know, commercially. So is that then classified as a domestic animal? So that is a very good question. I know TSA had an issue with peacocks. I believe an individual was traveling with an emotional support peacock,
Oh
and
gosh.
it was a big hullabaloo about whether it could be allowed. And I think a federal court had actually said at the time that it had to be limited to a different type of animal. But I don't know if that specific case has since been overturned.
Okay.
But I mean, I am more than happy to look up the answers to all these questions. So Sarah, if you want to email me after the presentation with the questions, and I can do my best to like find answers, I'd really like to try.
Oh no, absolutely. I'll be happy.
But that's a great question. You know, I kind of had a hunch the peacock was going to come up, so.
All right. Those are the questions we had. Christine, again, thank you very much. It was a wonderful presentation. I also
Thank
want
you.
to thank our ASL interpreters and everybody who is watching. I hope you had all your questions answered. If you do still have any that you would like addressed, you can contact North Penn Legal Services, or you can reach out to us at the Lehigh Valley Center for Independent Living. Thank you everybody so much for attending, and
Thank you.
Everyone have a great day.
You too. Thank you. Have a great day, everyone.
Bye-bye.